I'm an attorney and broker in California, real estate broker in California, and I'm really excited to read through this. I skimmed it just to make sure I'm not spinning any wheels because I kind of plan going live, but I am putting it on video, and I'm going to put it up on YouTube right after this. This is the California Association of Realtors response to the Burnett suit, and this is my mindset ahead of time. So you just know what my bias here. I believe we're going to have to go back to the previous model where we had the listing agent who contacts the sellers, working for the sellers, and if they're going to offer compensation to people who bring buyers to the table, those agents with the buyers are going to have to be sub-agents of the listing agent. So I think we're going back to the old model. Some of you old-timers will remember listing agent and selling agent. Now, I've also got ideas of how the buyers can be protected, and I also know how it can be done even with the current MLS system, and that's what I'm going to discuss in future videos. So I want to see how well my concept of where we're going jibes with what Carr says right now. And I'm going to point it out as we go through this. So I expect this to be long because it's this far and it's 5 pages. And I caught the headline down here on the second page, the Q&A. Now I might do a second video. I'm going to probably do the second video on the Q&A. So let's read this first, then we'll do the Q&A second. Okay, what is the Sitzer, and maybe we'll do the whole thing. Sitzer, Burnett versus National Association of Realtors lawsuit about, and what was the jury's verdict? This is great because we've seen a lot of different things on the net. I think they'll get this 100% right. This is a class action antitrust lawsuit filed in the federal court in Missouri. The plaintiff's class includes home sellers in Missouri who sold their properties between April 29th, 2015 and June 30th, 2022, using one of 4 local multiple listing services where commissions were offered from the listing agent to the buyer's agent. In 2019, the plaintiff sued NAR and 4 large brokerages, Anywhere Real Estate, which was Realogy, they're a huge one, Remax, Keller Williams, and Home Services of America. Plaintiffs claim that the defendants conspired to keep real estate commission rates high in violation of antitrust law, and NAR's cooperative compensation rule, MLS rule about offers of compensation from the listing broker to the buyer's agent through the MLS, causes sellers to pay too much in real estate commission. On October 31st, 2023, after an 11-day trial, the jury decided against the defendants and issued a verdict of nearly $1.8 billion. This amount could be tripled to more than $5 billion. I've read that the judge trebled it, but I'm going to go with what they know. The case is not over yet because NAR, Keller Williams, and Home Services of America have stated they will appeal. The 2 other defendants, Anywhere Real Estate and Remax, settled before the trial. Is there a lawsuit against Carr? No. This is probably going to get a national audience, so I'm not going to really go. Let's see. So nor other lawsuits filed against NAR and real estate brokers. So at the moment, Carr's not named. And I know I saw the webinar attorney. I've already forgot her name. I can see a picture of her face. I mentioned it. I was called Bolin. Was it Jenny? I don't remember her name, but she said she was hoping, or she kind of thought maybe the reason is because California Association of Realtors has very good forms keeping buyers and sellers informed. And I don't disagree with that. I just don't think lawyers are going to be prevented by forms if they've got people saying, they don't know what's going on. All right, so do individual Carr members have liability because they are members of Carr and NAR, or because they are associated with any of the franchise defendants? So this is very, very important. Do individual Carr members, so the realtors? No, the Sitzer, Burnet defendants are the franchise and NAR corporate entities. Plaintiffs did not sue and are not seeking damages from individual realtors. So that's with respect to that case, that answer. That's limited to that case. And if NAR was to survive, are they going to have to ask for an assessment from its realtors is still also a question. I could see a lot of realtors saying no, though, right? Why not just have them reform some other way? My main question still is, what are we going to do with Realtor.com? Should they still be getting all our data for free if you're a listing agent? Should all the brokers able to get our data for free and put them up on a national basis to bring in very valuable views and very valuable potential buyers? I think that's something we need to fix. So realtors, I'm completely on that side. If we're going to try to get back to market compensations and market levels, well, let's rearrange the whole industry so that the people helping the buyers and sellers actually get paid without conflicts, rather than letting Zillow and all the other major real estate portals make billions of dollars off the work of listing agents. You know, let's let the commissions go lower, and at the same time we could still have realtors make more if we set up the industry in a halfway rational way, rather than what I believe is a totally conflicted way it's been set up for the last who knows how many years, since well before 2004. Now, what are the next steps in the Sitzer-Burnet lawsuit? It's a pretty firm statement. NAR will post the necessary bond to appeal the jury's verdict, and NAR is confident it will ultimately prevail in this case. Also, NAR will ask the court to reduce damages awarded by the jury. Yeah. Good luck with that. I don't know. You know, if this is really the issue, okay, so I think I better come back to that. We'll discuss that at the end of this. How long will the appeal process take, and what is the likely outcome? The appeals process is very lengthy, and therefore the lawsuit will probably not reach final court decision for several more years. The trial judge hasn't issued a final order yet on the October 31st verdict, and we do not know whether there will eventually be any injunctive orders that might require defendants to alter their business practices or policies. So that's a little bit of a change. I think here they're admitting that the judge may try to craft some sort of final order that prevents realtors from offering co-brokes to buyer's agents. That will be interesting. Again, I've questioned whether a district court judge has that power, and who would he have that power over? Like, how would a circuit unless Missouri isn't the California's Ninth Circuit, I don't see how that's going to happen. I'll have to look at, I guess we need to look that up right now. What circuit is Missouri in, right? What circuit is the Missouri, I don't know how to spell Missouri, federal court in? Eighth Circuit. Let's just confirm what circuit is CA in. Ninth Circuit. Okay, so now I'm an attorney, so I'm going to opine on this. I have done appellate work in state court, so I understand the concepts, but I have not done appellate work in federal court. But I've read lots of decisions over my life, and I think it works like this. And lawyers, go into the comments and correct me if I'm wrong. There may be a chance the Eighth Circuit can control the way real estate's done in the states of which it has jurisdiction, and the Ninth Circuit might look for guidance. You know, there's other words in jurisprudence, but they might look for guidance from the Eighth Circuit, but they're not going to be bound by the Eighth Circuit. So eventually, I would expect splits of opinion across the circuits, because this isn't a clean-cut issue. My civil procedure lawyer, professor, who was a great professor, he might still be around, he became a pretty well-known crit, super bright guy from Yale, used to say, in the end, the cases that get up to the Supreme Court are frequently about two very strong competing interests. And it's usually the collision of both people's rights, and frequently constitutional rights, or other super strong rights. And it's a question of whose ox gets gored. So I see that this is how it's working, right? Now, maybe along the way, someone fashions a perfect response, a perfect answer, which I think is going to be the listing broker, selling broker combination. And that can make this whole crap tumble out into a more of a, I mean, it would make new plaintiffs have to start all over again, right? They'd have to try a whole new set of circumstances, how to find a whole new set of plaintiffs, and the business could go in a very orderly fashion still. But absent that, I think it's going to be a long time till it gets to the Supreme Court, if they even want to hear it, and decide whose ox gets gored. And where does the ox get gored? I was doing it with my hands. Apparently, when they're plowing fields, oxen sometimes lock horns, and the only way to get them apart is by goring one with a sword. I've seen dogs like that. Like, the only way to get them apart, people say, oh, you're going to have to kill the dogs one of the dogs, and someone eventually came along with some mace, and that did break them off. But if you've seen that, that's the point. Collision of constitutional rights. So right now, I can see Carr being pretty confident that it's going to be a while before we get slammed out here. The lawsuit's going to have to start first. But that may be discussed in a second here. The appeals process is very lengthy, and therefore this lawsuit... Oh, no, we read that. Okay, so after these appellate briefs are filed with the Court of Appeal, Carr will have better information about the specific legal arguments and grounds supporting the defendant's appeals. Right, that will be interesting. Yeah, very interesting. This, as I said, it looked like a pretty specific case up here. We'll talk about that in a little while. As noted, who will receive damages from the payouts? As noted, it will likely take several years before there's a final decision in the case. Well, we know the lawyers are going to get paid, right? Quite handsomely, I'm sure. If the jury's verdict is ultimately affirmed and the defendants need to pay the damages, and each of the members of the plaintiff's class, home sellers in Missouri, during the relevant time period, and their attorneys would receive payment. Can you imagine the billions of dollars? Whew. I don't know how these defendants survive that. What are the Sitzer Burnett settlements for Anywhere and Remax? It was $83.5 million. I don't know that we need to read all that. Well, let's go. I'll read it. The proposed settlement includes required practice changes, including prohibiting company-owned brokerages and their affiliated agents from claiming buyer agent services are free. Yeah, that they all, I've always struggled with that in my marketing, and the few videos that I remember saying no extra costs out of your pocket or nothing more out of your pocket. I've always thought that free was very questionable, and I'm pretty sure all my videos would have said nothing more out of your pocket as opposed to saying free. So that's the result of untrained people not really being worried about being sued for lying. Requiring the inclusion of the listing broker's offer of compensation as soon as possible in active listings consistent with the MLS. Listing broker's offer of compensation. Requiring the inclusion of the listing broker's offer of compensation as soon as possible in active listings consistent with MLS rules and capabilities of third-party website operators. Oh, so this is this is where now we're going to see the compensation offered across every website. I think that's a great thing. And it especially allows for the flexibility of changing them, so they have to make rules about changing them, because I could see the offers of compensation changing after a week and after a month in strategies that I've favored for years. And so those things are going to need to be updated almost instantaneously to be useful. Prohibiting the use of technology or manual methods to sort listings by offers of compensation unless requested by the client. Okay, so that's a super, these lawyers, someone was thinking, right? So this is like, they don't want agents, buyer's agents, to be able to sort by compensation. That's bullshit, right? Let's see if that actually, let me see if this is the English, if this is prohibiting the use of technology or manual methods to sort listings by offers of compensation unless requested by the client. Okay, so if a client's offering 4%, they want that sort to go to the top. I want that. This is super valuable for a person who uses the strategy I've talked about. Sometimes you want to pay more than the customary amount. So yes, I want it to be sorted by that. Now, someone offering 1, 0, 1, 2, or 3 doesn't want it sorted by that. But now that's baloney. That's being in the pot. That's tantamount to saying I want buyer's agents to work stupid. I mean, why should someone working with the buyer be forced to work for 0 or $1 or 1% if their time is valuable to them? This is a mess. This disgusts me, actually, right? Because I don't need to ever work for a buyer again as a buyer's agent, but I also don't think any buyer's agents should have to sell my property if I've offered 1% or 0. And I understand I've helped people sell homes by putting $1 in the MLS. And I've called up the agents and they've got upset with me. And I said, I understand. I go, but I also have a seller who has reasons. And they usually understand it. Sometimes it started off a little quarrelsome, but they understand. Like most of the time, either it was a limited amount of, they were trying to avoid short sales, so it was a limited amount of equity, or there were other reasons, and the people needed all the money. And I said, I'm either taking 0 or 1 or something low, and the buyer's agents backed off as soon as they found out I wasn't the one trying to be the greedy one. So this is crazy. So again, we're going to go back to the previous models, because an agent should be allowed to say, look, I sorted on here. These are the ones I can work with you on. These are the ones that you're not. And you can see why, just like I told you, I can't work for 1%. You don't want to pay a contingency. You don't want to pay me a flat fee to get started, which I understand too. Anywhere real estate agreed to deposit $10 million in the settlement fund after preliminary court approval is granted, $20 million after court approval of fees and costs, typically granted with the court's final approval, and the remaining balance after final court approval and all appellate rights are exhausted. Wow. The lawyers were stoked. Their years of work was just, made break even or better. A few weeks after the above settlement, RE/MAX agreed to a similar settlement for $55 million and agreed to make similar changes to its business practice. The RE/MAX settlement also requires court approval. Why didn't NAR settle? Due to their extremely sensitive nature, settlement negotiations are conducted with the strictest confidentiality by the parties and their attorneys. Therefore, so far that's like boilerplate, right? Therefore, CAR doesn't have information about the possible settlement discussions or offers that might have been made to NAR, and CAR doesn't know whether plaintiff offered any settlement deals that were reasonable. It is possible there will be future settlement discussions between the parties. However, at this, I feel like I need to be because I'm going to talk a lot today. I got to go lower in my register here. However, at this time, NAR is pursuing an appeal and confident it will ultimately prevail in this case. Standard response: CAR doesn't know, don't know why. Think about this. As I said earlier, if CAR agreed that sellers could not compensate, offer co-broke, they would have been no longer serving the interests of all the people who have buyers, who have agents who work with buyers in their office, whether it be buyers agents or just sometimes sellers agents. Listing agents who double side, that's a separate video. What that's going to be, where does this eventually settle out? Is it going to be 3%, 4%, 5%? What are you going to have to pay? What is a seller going to have to pay a listing agent to work on their home? I think it's going to differ. I think the franchises are no longer going to be able to say, we want a lot of money, or we want X, and you have to charge at least this because we have to hold our businesses together. So I suspect that commissions will come down, and maybe dramatically, but this is because this, not necessarily because we're not going to be offering co-brokes, but because I don't think the franchises are going to be able to say, you can't take a listing for less than 5 or less than 6 or less than 4. It depends. Okay, can real estate brokers that settle in the Sitzer Burnett case be sued again in a different lawsuit? It depends on specific facts and circumstances. That's res judicata, right? Has this matter been litigated before and it's been settled? If it's different, yes. If not, it can't be. It is possible for a real estate brokerage that was sued in the Sitzer Burnett case to be sued in other different lawsuits by different plaintiffs who might allege new or different types of claims. However, depending on the conditions outlined in the final court-approved settlement agreement involving real estate brokerage, there may be protections that would limit or prevent future claims against brokerage that has settled. For example, if the Anywhere Real Estate and RE/MAX proposed settlements are approved, the released franchises and their franchisees and affiliated agents should be protected from many similar antitrust claims. It's beyond my it's an interesting angle. I would have said they're protected from being sued by this class, but they're saying from similar antitrust claims. I'm not, wish my father was still alive. He had a master's. No, he had at least a master's in antitrust law and did that for a Q, will NAR file for bankruptcy? He was also, in case you saw my videos, he was also a litigation attorney. But when, long story, it doesn't matter. Will NAR file for bankruptcy? It is too early to speculate about the possibility of bankruptcy because the Sitzer-Burnett case has not reached a final resolution as NAR plans to appeal. It is uncertain whether NAR and the co-defendants will ultimately need to pay any damages, or if they do need to pay, how much they will need to pay, because maybe they'll settle it down, negotiate it down instead of following this appeal all the way. I know if I'm a plaintiff's class action attorney, and I don't know how many they have, but if I could get $10 million in my pocket now, or maybe $30 million in my pocket later, I'm thinking about $10 million in my pocket now. Now, how that affects the class, I think it would be similar. Hey, all you sellers, you could get this money now, or you can wait however long the appeals process is, and maybe get more, maybe get less, maybe they lose on appeal. So there is an amount that would settle, I believe. Well, there is an amount that would settle in a non-class action suit. I don't know enough about the pressures on class actions to settle, to really speculate further than just human nature. Now, can NAR pay for the necessary bond to proceed with the appeal? Yes, NAR has stated it's sufficient funds. Well, I'd still like to see it before I believe what NAR says. They almost have to say that, right? And they may. I'd just like to see how they're going to do it, because it's a lot of money. Will NAR increase its dues to pay for this and other lawsuits? NAR stated it does not plan to raise members' dues. Well, I certainly hope not, because they're already pretty high, in my opinion. Do smaller independent brokers have the same risk of being sued in similar antitrust lawsuits? Okay, so I saw this on the webinar, and the answer was no. Now, let's see if they use the same arguments, because it was the plaintiffs go after the mountains, and plaintiff lawyers go after the mountains of money. Let's see if they say something a little more lawyer-esque. There's a much lower risk because class action plaintiff law firms usually target large corporate defendants with a huge client base to ensure there's a large pool of consumers fitting within the description of the class, okay, and potential higher dollars for pleaded damages. Yeah, so the mountain of money. To proceed with a class action, plaintiff law firms need to certify the class by demonstrating the plaintiffs are all similarly situated, which is a high burden by itself and much more difficult to achieve if defendant brokerages are independent and have different company policies and practices. Also, plaintiff law firms usually target larger companies because it's more likely companies have a lot of money to pay damages. A double portion of mountain of money and potential higher dollars for pleaded damages. Okay, very well answered. Let's put it that way. Now, what does that mean? Well, other than the fact that these lawsuits are an existential threat to these large national franchises, because of the dollars involved, and because I suspect a lot of us know that there's been lots of training over the years about how to get full price listings, and we've been at brokerages where there was no option. You had to any number less than you took, then that number came out of your commission, to the point where you could only reduce like a percent before you were getting nothing. Because of practices like those, if winning by the plaintiff's class action lawsuits depends on this theory, that by training their agents to get full price listings and demanding full price listings, they were committing antitrust violations, I think that there's a chance they're gone. Right? I really do. Now, going forward from this day, what should brokers do for those franchises? And then I'm a broker. For what I would do, I will tell you, I spent a lot of time thinking about this the last 24 hours. I've already let on hints, but I'm going to go through the forms and show you what I would do. I'm going to go through, I probably at some point might even, I'll do some other things. I think that especially, I'm going to let you all talk to your lawyers. I'm just going to say I would change my practices immediately. I'm not saying I don't want to see agents who might be working with buyers before they make an offer get paid, but there's no way I'm going to let my brokerage be on the hook for paying co-ops to brokers and conspiring to keep commissions high. Consequently, commissions are going to come down on a relative basis. Strong agents who have lots of listings and selling houses for top dollar, have great reputations, may make the same. Some people working with buyers may get more than 3 or 4% in certain circumstances. But there's going to be agents competing with all those, competing on price. Those prices are going to come down. If you're a broker and you're working for a franchise, do you really want plaintiff's class action lawyers to know that you said you can't take a 1% listing or 1% more than the franchise's fee listing to a listing agent in your office? Would you really, 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 really want to put your name behind that? I don't see how anybody who wants to sleep at night can. Tell me if I'm wrong in the comments, please. I don't want to be right. I just thought about this for a long time, and I'm telling you, because I'm a broker, I know what I'm going to do. And I'm going to talk about it in the next video. But I'm going to be we're going to be flexible on commissions. Period. I personally may not be, but the agents in my office are going to have to be. And a franchise, you can't take 1 or 2%. Your realtors are going to leave on a listing. So what are your numbers at a listing? 20%, maybe up to $30,000 a year, and then $100 or $200 after that. You have some small fees. Now, that's really where your number is. You can't say you must take 3%. I don't see how I just don't see how that would be wise given what we're seeing here. Conspiring, a franchise cannot be seen as working to keep commissions high in an antitrust, in a way that could violate antitrust laws. And so individually, as a broker, I just wouldn't be doing it. It's very simple. I want to sleep at night. Now, if your franchise says you got to do it and you'll lose your job if you don't, now what? What is the Gibson class? Okay, so what is the new Gibson class action filed against NAR, Compass, EXP, Redfin, and other brokerages about? This is a great question. I was trying to get to the bottom of this 3 days ago, and it wasn't all that clear to me because I kept getting I never got the complaint. Couldn't find it. I saw lots of little pieces of it about the some motions, but I didn't find the plaintiff. So this is good. This is great, actually. Thank you, Carr. After the jury's verdict in Sitzer Burnett case, this is different. The same plaintiff's attorney filed another antitrust lawsuit, Gibson et al. Versus NAR et al. In the same Missouri federal court, alleging very similar claims to those contained in the Sitzer Burnett lawsuit. This lawsuit alleges a nationwide class, including home sellers who listed a property for sale in the MLS with one of 7 named brokerage defendants and who paid a buyer broker commission from October 31st, 2019 to the present. Oh my goodness. Since this lawsuit was just filed last week, there is very little available information at this time about the defendants' responses. Oh. I'm going to reread that. After the jury's verdict in the Sitzer Burnett case, the same plaintiff's attorneys filed another. So now they're well funded too, because I got those millions from Remax, I think it was. We saw it there. One of the firms. Alleging very similar claims to those contained in the Sitzer Burnett lawsuit. This lawsuit alleges a nationwide class, including home sellers who listed a property for sale on the MLS with one of the 7 named brokerage defendants and who paid a buyer broker commission from October 31st, 2019 to the present. It's what was that, existential threat? Just think about that we're going to be paying on lawyers. And they've already just paid out millions for the Missouri case, and now they're on the hook for a nationwide case? What kind of numbers are we looking at? And after this is entered or within a few days, the plaintiffs' lawyers are going to have millions of dollars from the settlement? You know, the PGA thing about these guys are good? Yeah. Remember they used to say these guys are good? Well, these plaintiffs' class action attorneys. Wow. Is there a possibility for a class action lawsuit in California? Although it's possible, there are factors that would probably make it more challenging to file a similar California action, including California laws that confirm the pro-consumer and competitive benefits of MLS. Is MLSs? MLS, plural. In addition to the wide variety of broker business models which give consumers many choices and promote robust competition in the California real estate market. Having said that, CAR continues to remind members that they should have open and transparent discussions with their clients about their compensation, including the negotiability of real estate commissions and other types of broker compensation. Well, all true and all really spun in the best possible light. And maybe the attorneys at CAR are correct that our forms are good and people are informed. But when plaintiffs' class action lawyers are in California and they're talking, if they can get a bunch of listing agents who worked at big firms to talk about how they were trained to keep commissions up, and they find out that some of the brokerage models provided very little opportunity for listing agent discounts. When you combine those factors, I'm not sure that the forms are going to save them. Does the Sitzer-Burnett verdict affect the Department of Justice settlement with NAR? Now, that's, I guess, what I was referring to earlier. Not directly, although DOJ is probably monitoring developments in the Sitzer-Burnett case and other antitrust lawsuits. NAR previously reached a settlement agreement with the DOJ in 2020. The DOJ has also actively been filing some briefs or statements of interest in many of the MLS-related lawsuits. We do not know whether the DOJ will take further action related to real estate business practices and commissions in the future. This is okay, so I'm going to cut this off in a second, but I want to make a comment about that and then we'll cover the next one. I don't know, but if you're like me, okay, I'm a lawyer and a realtor, right? So remember all those lawyer jokes and everyone hated lawyers? And then somehow, like I remember, my wife and I sold a house in Carlsbad. It went up really fast in like 3 or 4 years. And we're like, and we had some money from the house, and I had made money from shorting internet stocks. I was trading every day back then and killed it. We went to Florida with a pile of dough to become real estate investors. My friends living there said houses still pay for themselves, even if you take out a loan. But during the 3 or 4 months we were traveling around visiting relatives before we bought a home, prices had gone up and that was gone. So I got there. I had 3 or 4 houses. I became a realtor. I passed the bar exam there. And where was I going with that? Does practice commissions in the future? I'm sorry, I lost my train of thought. Not directly, although DOJ is probably monitoring developments. The DOJ has actively been filing some statements of So when I got to the DMV to get a license in Florida, the lady at the DMV desk said, "Well, what do you do?" And she goes, I said, "Well, I am an attorney in California, but I came here a month ago and I passed the realtor exam here, and so I'm going to be a realtor in Florida." She goes, "I think I liked you more as an attorney." And that was right around the time realtors became hated. And I said in the other video, it's not just realtors make a lot of money. Doing little work is what some people think. They have no idea how much time realtors spend marketing. But on their files, they get paid, and a significant portion of their equity goes to realtors, and they hate it. But they also hate the fact that the transactions look set up to make realtors happy and protect realtors and not make anyone else happy. Like, that's why they think realtors are terrible. They're greedy, they self-deal and all that. That's why the process needs to be far more transparent. Let me write a note down to myself for the next video. I've already forgot it, but we'll get to it. Now, what impact will antitrust cases have on the relationship between NAR and CAR? Good question. Excellent question. Currently, there is no direct impact on the relationship and local associations of realtors. The Sitzer-Burnett case is not over yet. CAR will continue to serve and support its membership by providing a vast suite of member resources and business products, in addition to strong political advocacy on behalf of California realtors. Let me just say that I don't like how much I spend, but the CAR forms are good. CAR legal's good. They're smart when you talk to them. So, for a little bit less money, I might even join CAR without being forced to. Or, CAR's close to a good value, a reasonable value. So I hope they survive, but we'll see. Now, does that mean I hope that practices continue the way they are? Absolutely not. I think what's happened is realtors were allowed to practice law without a license because of these good forms and these trade associations, and that would have saved these massive brokerages, had they been protecting buyers more properly, avoiding these conflicts of interest, probably just having attorneys on the files more often or all the time. Let me skip that. I don't know about Missouri law. I'm saying that I think that if realtors had protected buyers more, and had some attorneys on these files, this existential threat to real estate brokerages wouldn't exist. There was so much money in these files. Make your clients feel good, like they're also protected. Don't use these forms as a way to let realtors act like they can comment on things that they really have no business commenting on. That's the thing. And I know good, strong realtors absolutely agree with that sentiment. It's the ones that have spent a lot of time on marketing and very few clients that want every dollar to themselves. That's the problem. So really, we'll talk more about that. I'm going to discuss the Q&A next, but I think this was long. I'm going to get myself another Pellegrino. I'm going to let this upload, and then I will come back and do that. And really, by the end of the day, sometime I got to get to the gym and work out, but by the end of the day, I want to go through and discuss what I think is the way to go forward if you're a broker on your own or with a franchise, and where I'm going to, I hope a bunch of us lawyers and realtors lobby the MLS for us to go back to the selling agent system. I'm going to tell you why. I'm going to talk about the addendum that I'm going to include, that I advise people to include with every listing, or at least contemplate it. And I'm going to go through the forms. I don't know if I'm going to get that all done today, but these are going to go up to my website and YouTube, and they're going to go into, all this is going to be part of a program at winnerscheck.org that really hasn't formed yet, so I've got nothing to offer you. And maybe it'll be winnerscheck.com too. I think right now org is going to be where the programs are, but .com will be forward-facing. And people say, well, why Winners Check? And I go, well, one, it's easy to remember. Like I was like, well, what does Amazon have to do with books, right? I keep saying, well, what does that got to do with the topic? I've heard it from multiple people. And I don't care. I like Winners Check. But the reality is, I want to say, before people buy and sell real estate, Winners Check. That's really where I'm going with this. I know it's whatever. All right. John McConnin, broker and attorney in California. Please, questions. I want to do videos like this every day. My goal is to get into the 10-minute mark. Put those questions up there. Thanks. Talk to you later. Bye. Like and subscribe. Let's get this stuff, let's get people well informed.